In property law, an easement, which is the right to use or enter onto another's land, can be appurtenant, which is attached to the land, or in gross, which is personal in nature. In addition, an easement can be affirmative, which allows the holder to use the land, or negative, which allows the holder to prevent an otherwise permissible use of the land. In United States v. Blackman, the Virginia Supreme Court considered whether a landowner could validly convey a negative easement in gross for the purpose of land conservation and historic preservation. In the early 1970s, the state of Virginia bought land in the Green Springs Historic District and planned to build a prison on it. Local residents opposed the plan, and the state promised not to build the prison if the land could be preserved. Residents then organized Historic Green Springs Incorporated, which we'll call HGS, a nonprofit group, to preserve the land. Many landowners in the district granted HGS easements for conservation and historic preservation. In 1973, D.L. and Francis Atkins granted HGS an easement over several parcels of their property, including Eastern View Farm, which included a manor house. The deed of easement provided that the property had to be maintained in its present state and that the property couldn't be altered without HGS's prior written approval. In 1978, HGS conveyed the easements to the United States federal government. The original easement grantors agreed to the transfer and signed the deed. Afterward, the National Park Service, or NPS, administered the easements. In 2002, Peter Blackman purchased Eastern View Farm and wished to renovate the manor house. He submitted several sets of renovation plans to the NPS for review, but they were rejected. Instead of waiting for NPS approval, Blackman proceeded with his renovations. Subsequently, the United States sued Blackman in federal district court, seeking a temporary restraining order preventing him from continuing renovation work. In response, Blackman argued that the original deed of easement was invalid because, at the time it was created, Virginia didn't recognize negative easements in gross, including those for land conservation and historic preservation. The court granted the injunction, concluding that Virginia hadn't addressed the issue of the validity of negative easement in gross, but that it was recognized at common law. The court then certified the question to the Virginia Supreme Court.